A Diuk, 300 characters. In 2026, a court index revealed something that should not exist. A family trust still listed as active, despite an estate closed more than a century ago. No lawsuit explains it. No scandal records it. Only a quiet decision that never expired. This video examines how a single family trust, recorded in 1894, remained legally alive long after its heirs disappeared from the record, and why a register card retrieved from the Surrogates Court of New York County in 2026 confirms that the trust was never formally closed, a decision that reshaped an entire inheritance without ever being contested in public. At the height of the Gilded Age, inheritance was not simply a transfer of wealth. It was a matter of reputation, continuity, and control. In the decades following the Panic of 1893, American elite families became acutely aware that fortunes could be diluted not only by markets, but by heirs who failed to meet social, marital, or behavioral expectations. Trusts were the solution. They offered stability on paper and discretion in practice, allowing wealth to survive its owners while remaining insulated from public scrutiny. By the mid-1890s, New York had become the administrative center of this system. Courts processed estates with mechanical efficiency, newspapers tracked prominent deaths and bequests, and society columns quietly assessed what each inheritance signaled about a family's standing. A fortune granted outright could empower the wrong marriage, attract unwanted litigation, or invite speculation from rivals. A fortune placed in trust, however, could be shaped, delayed, and, if necessary, withheld indefinitely. In 1894, one such trust was formally granted. The estate was probated, the language precise, the intent outwardly conventional. On paper, the inheritance existed. The trust was indexed, recorded, and acknowledged as part of the legal machinery of the city. Nothing in the public notices suggested controversy. Nothing in the press hinted at internal conflict. The process appeared complete, and yet, more than a century later, the trust remained active. When a researcher requested the original file in 2026, the expectation was administrative routine. Estates from that era are typically marked closed, dormant, or destroyed according to schedule. Instead, a register card was retrieved that bore no termination date. The clerk confirmed what the index already implied. The trust had never been dissolved. It had survived wars, reforms, tax revolutions, and generations of silence, legally intact, practically unreachable. This is where the case becomes uncomfortable. A trust that never ends is not an accident. It requires ongoing recognition, procedural continuity, and the absence of challenge. Someone at some point chose not to resolve it, and that choice carried consequences that extended far beyond the original heirs. The late 19th century was an era obsessed with appearances. Public image determined access to capital, marriage alliances, and political influence. Decisions made behind closed doors were rarely documented in full, but their effects were visible in what quietly changed. Names that stopped appearing in records, assets that shifted custodianship, legacies that became strangely abstract. The press reported what it was allowed to see. The courts processed what was presented to them. Everything else was managed privately. This trust existed at the intersection of those worlds. Publicly, it was a settled inheritance. Privately, it functioned as a gate. It preserved wealth while denying possession. It allowed control to persist after death without provoking dispute. And because nothing overt was broken, nothing needed to be repaired. If a trust can remain legally alive without ever being claimed, what does that say about ownership itself? And if this raises questions for you, which archive or ledger would you open first? And consider subscribing so you don't miss the next file. And if this intrigues you, leave a like. What follows is not a story of theft or forgery, but of administration, the kind that leaves no scandal, only permanence. And it begins not with a fortune changing hands, but with a thin card sliding across a wooden counter, its final line still blank. In 1894, the appearance of a formally recorded trust indenture at the New York County Clerk's office was not by itself unusual. What gave the document weight was the moment in which it emerged and the environment that shaped its language. This was a period when the American elite had learned that inheritance could become a liability. Wealth passed too freely risked scandal, unwanted alliances, and public litigation. Wealth constrained by law, however, could be preserved without explanation. By the early 1890s, New York had become the administrative capital of American inheritance. The city processed estates not only for residents, but for families whose wealth extended across railroads, banking interests, and urban real estate. The Panic of 1893 had already demonstrated how quickly fortunes could weaken when markets turned and heirs proved unreliable. In response, elite families turned to trusts not as neutral instruments, but as mechanisms of discipline. A trust could postpone ownership, fragment responsibility, and place decision-making power in the hands of individuals who were not named heirs at all. The indenture recorded in 1894 reflected this mindset. Its clauses were not written to distribute wealth efficiently, but to regulate behavior over time. Conditions appeared cumulative rather than sequential, requiring compliance with multiple standards before any access could be considered. Marriage was not merely expected, but subject to approval by trustees. Residence abroad was framed not as preference, but as obligation, tied to vague notions of cultural refinement. Social standing was implied as a measurable requirement to be affirmed by unnamed third parties, whose authority was never defined. The action that made this structure real was administrative and precise. The document was reviewed, protocol numbers verified, and rubrications checked against the clerk's ledger. Once accepted, it became part of the permanent record. The law did not question intent, it confirmed form. In doing so, it transformed private expectations into enforceable constraints. The consequence was immediate and enduring. What appeared to be an inheritance became a system of control that could persist long after the individuals it governed had disappeared. This mattered in 1894 because the press watched estates closely. Newspapers regularly published summaries of wills, inventories, and notable bequests, framing them as indicators of moral standing as much as financial success. A contested inheritance suggested disorder. A delayed inheritance suggested prudence. A trust with complex conditions suggested responsibility, even when those conditions made access unlikely. The absence of controversy was itself a signal that the family remained in control. Elite legal practice reinforced this logic. Attorneys advised clients that a trust designed to be difficult was preferable to one that could be challenged. Ambiguity favored administrators. Specificity favored heirs. The indenture followed this principle carefully, relying on terms that were enforceable yet elastic, precise in appearance but open in application. It placed authority in the hands of trustees whose decisions were shielded by fiduciary language, making refusal indistinguishable from protection. The risk, had the structure been simpler, was not merely financial, it was reputational. An heir who gained unrestricted access could act independently, marry without approval, sell property, or expose internal disputes through litigation. In an era when family names functioned as economic assets, such autonomy was dangerous. The trust indenture neutralized that risk by separating legal existence from practical access, ensuring that ownership could be acknowledged without ever being exercised. By anchoring these conditions in a publicly recorded document, the family achieved a paradoxical result. The trust was visible, legitimate, and unremarkable. At the same time, it was insulated from challenge by the very complexity that defined it. Courts recognized its validity. Clerks indexed it routinely. Journalists had nothing to report beyond its existence. Silence became evidence of order. The real consequence unfolded over time. As years passed and compliance with the conditions grew less plausible, the trust did not fail. It endured. Each unmet requirement reinforced the authority of the trustees and postponed resolution. The inheritance remained present in law, but absent in practice, a legal entity without a beneficiary capable of satisfying its terms. By the turn of the century, this approach had become normalized among old money families. Trusts were no longer tools of transition, but instruments of continuity, designed to survive heirs rather than empower them. The 1894 indenture fit seamlessly into this pattern. It did not announce its purpose. It executed it quietly, through language that converted social preference into legal fact. What remains is not a dramatic omission, but a carefully constructed environment in which nothing needed to be removed. The document stayed where it belonged, bound, indexed, and intact. Its power lay not in what it concealed, but in what it made conditional. And as the ledger closed on that year, the trust's name sat in ink, ordinary and complete, waiting for a future moment when someone would finally notice that it had never been allowed to end. By 1895, the risk surrounding inheritance in New York was no longer abstract, and it was no longer private. Wealth at that level moved through a narrow corridor of institutions that watched one another closely: courts, banks, trust companies, and the press. Any fracture in that corridor, any hint that an estate was unstable, contested, or poorly controlled, had consequences that extended beyond the family involved. The danger was not simply the loss of money, but the exposure of vulnerability in a system that depended on the appearance of permanence. Fifth Avenue families understood this well. Their fortunes were intertwined with credit, property, and social alliances that assumed continuity. A clean probate signaled competence. A disputed one raised questions that could stall transactions for years. In 1895, probate notices published in New York newspapers were read not only by the public, but by bankers, attorneys, and rival families, assessing one another's stability. A name appearing too often in the legal columns suggested disorder. A name disappearing entirely could suggest something worse. Trusts intensified this scrutiny. While they offered protection, they also introduced complexity that could alarm outside observers if not managed carefully. A trust that appeared vulnerable to challenge could invite litigation from distant relatives or creditors. Worse, it could signal to banks that collateral tied to the estate was uncertain. Financial institutions responded conservatively. They demanded additional guarantees, delayed loans, or reclassified risk. The action was procedural, not punitive, but the consequence was immediate. Liquidity tightened, leverage weakened, and negotiating power diminished. The surrogate's court of New York County sat at the center of this system. It was both a legal forum and a public stage. Estates passed through it in full view of the institutions that mattered most. Judges were cautious, clerks meticulous, and records accessible enough to allow scrutiny without revealing internal strategy. Once an estate entered the court, its handling became part of a family's public profile, even if no dispute ever reached a hearing. Trust companies played a parallel role. The U.S. Trust Company of New York, among others, marketed itself as a stabilizing force, capable of insulating wealth from the unpredictability of heirs and markets alike. But their involvement also signaled that control had been delegated. For families concerned with authority and legacy, this delegation had to be framed carefully. Too much trustee power suggested distrust of heirs. Too little invited intervention from courts and creditors. In this environment, generosity carried risk. An heir who received wealth outright could act independently, exposing the family to reputational harm through personal behavior, marriages, or business decisions. A trust with permissive terms offered little protection if challenged. The safest structure was one that appeared benevolent while remaining functionally restrictive. Conditions could be justified as prudence. Delays could be framed as stewardship. Silence could be explained as discretion. The press amplified these calculations. Society pages chronicled deaths, bequests and marriages with an attention that blurred the line between reporting and evaluation. A large inheritance granted without conditions invited commentary. A trust with vague purposes invited none. The absence of detail was often interpreted as evidence of careful planning rather than concealment. Families learned that the less said publicly, the less could be questioned privately. Legal reforms on the horizon intensified this caution. By the late 1890s, lawmakers were already debating changes to inheritance and taxation that would later reshape estate planning. Families with complex holdings understood that what appeared acceptable in 1895 might be scrutinized a decade later under new rules. Structures that minimized visibility and postponed resolution offered insulation against shifting standards. A trust that never reached distribution could avoid recalculation altogether. The action taken in response to these pressures was subtle. Estates were not openly altered, but strategically framed. Documents were drafted to emphasize protection and maintenance. Access was conditioned, not denied. Authority was centralized in trustees whose discretion was shielded by fiduciary language. Each choice reduced the likelihood of public challenge while increasing institutional control. The consequence of failure, had these measures not been taken, was clear. A single contestation could freeze property transfers, delay sales, and invite examination of related assets. Creditors could petition the court, newspapers could speculate, alliances built on perceived stability could weaken. In a society where reputation functioned as capital, such exposure was costly. By 1895, then, the risk was not that a trust might be questioned, but that it might be questioned at the wrong moment, under the wrong conditions, by the wrong audience. Families acted to ensure that moment never arrived. They designed systems that could endure quietly without producing events that demanded explanation. What this created was a narrow margin for error. Every record had to align. Every action had to appear routine. Anything that deviated from expectation had to be absorbed without trace. In that sense, the environment itself dictated what came next. Control became not merely preferable, but necessary. As the decade progressed, this logic hardened into practice. Decisions were made behind closed doors, justified in administrative language, and executed through institutions that valued order over transparency. The risk had been identified, measured, and contained. What remained was to formalize that containment in a way that would not attract attention. The paper trail from this period reflects that priority. Notices are brief, filings are precise, explanations are minimal. The record shows a system working as intended, smoothing over potential disruptions before they could surface. And as the final notices of 1895 were filed, the stage was set for a choice that would not be debated in public, but would shape the inheritance irrevocably. a choice made in a room without reporters, recorded only in the language of authorization, waiting to be enacted. In 1896, the estate stopped being managed as a matter of succession and began to be treated as a matter of governance. The shift did not occur in court and did not leave behind a ruling. It took place in a professional office during a scheduled meeting that appeared, on paper, indistinguishable from hundreds of others that occurred that year across Lower Manhattan. What distinguished it was not its form, but its outcome. The meeting was logged in an internal agenda at Cadwallader, Wickersham and Taft, a firm already established as a legal backbone for elite families whose wealth depended on discretion more than growth. Present were the appointed trustees, outside counsel, and a representative of a trust company responsible for administration. The stated purpose was procedural review. The actual purpose was containment. By that point, the trust instrument recorded in 1894 had proven legally sound but socially exposed. Its conditions were enforceable, yet they left too much room for future interpretation. As heirs aged, as marriages occurred, as reputations evolved, the possibility of challenge increased. No one in the room spoke of conflict in emotional terms. The language was institutional. Risk mitigation, preservation of name, avoidance of public dispute. The action taken was neither dramatic nor illegal. A directive was approved to reinterpret the trust's purpose from eventual distribution to ongoing stewardship. This was done through authorization rather than amendment. No public filing was required. The trustees were granted expanded discretion to evaluate compliance, defer decisions, and prioritize what the minutes referred to as family integrity. The trust company agreed to administer under this revised posture, recording distributions as conditional and provisional, even when conditions had technically been met. The consequence of this decision was structural. The estate ceased to function as a bridge between generations and became a closed system. Access was no longer a matter of time or fulfillment, but of judgment. The trustees' role shifted from executors of intent to custodians of outcome. Their authority now extended beyond the text of the original indenture into the realm of interpretation, where refusals could be framed as protection and delays as prudence. This mattered because it altered the legal posture of any future challenge. An heir could no longer point to a missed condition and argue breach. Each request would be evaluated individually under standards that were deliberately elastic. Compliance became subjective, denial became administrative. The trust, as a result, gained a form of durability that outright ownership could never achieve. The bank's representative raised no objection. From an institutional perspective, the arrangement was ideal. Assets remained under management, fees continued, exposure was minimized. The trust company did not acquire ownership, but it acquired permanence. Its role became synonymous with stability, a quality that carried weight with courts and counterparties alike. Nothing in the record suggests dissent. The minutes note agreement, acknowledgement, and closure. The document was marked confidential and filed internally. No copy was submitted to the court. No notice was issued. From the outside, nothing changed. From the inside, the inheritance had been reclassified from property to policy. The cost of this decision was not immediate. It would be paid over decades in the form of silence. Heirs would encounter delay without explanation. Requests would be met with references to review. Over time, the absence of resolution would appear natural, even expected. The trust would age into its new role, outliving not only its beneficiaries, but the circumstances that produced it. By the end of that meeting in 1896, the estate had been converted into a system. It no longer required action to maintain control. It required only inaction. And as the participants gathered their papers and the clerk closed the agenda, The final item on the page, a brief note authorizing administrative adjustment consistent with fiduciary discretion, sat beneath a neat line of signatures ready to be implemented in the real world. In 1897, the change did not arrive as a correction, nor as a reversal of what had been filed 3 years earlier. It arrived as an addition. The public record shows it as a codicil, a supplemental instrument attached to the original trust indenture and re-recorded under the same indexing logic at the New York County Clerk's Office. On its face, the action appeared routine. Estates were adjusted all the time. Language evolved. Administrators clarified intent. Nothing about the filing itself signaled disruption. The alteration becomes visible only when the two versions are placed side by side. Version A, recorded in 1894, defines a beneficiary in broad terms, tied to lineage and formal recognition. Distribution triggers are structured around compliance, but the language leaves open a theoretical path to access. Version B, entered into the record in 1897, narrows those definitions without announcing the change. The term beneficiary is reframed through layered qualifiers. Eligibility now depends not only on status, but on continued approval, assessed at the discretion of the trustees. Distribution triggers are no longer events. They are conditions subject to ongoing review. The action that made this effective was administrative rather than judicial. The codicil was accepted, stamped, and indexed. In parallel, the surrogate's court docket reflects a notation referring to supplemental filing without a corresponding hearing or order. The absence of adjudication is critical. Nothing was challenged because nothing appeared to be taken away. The document did not revoke the inheritance. It redefined how it could be reached. Within the text, new phrases appear with institutional precision: restricted handling, sealed exhibits, subject to trustee determination. These were not ornamental terms. They carried procedural weight. Restricted handling limited who could request the file and under what circumstances. Sealed exhibits removed supporting documents from the general case packet, separating context from content. Trustee determination replaced objective benchmarks with discretionary authority. The concrete change in the world followed immediately. Clerks handling subsequent inquiries were directed to consult internal notes rather than the public file. Requests were acknowledged but deferred. Copies were produced without attachments. The trust remained visible, but its operational core moved behind administrative barriers that did not exist in 1894. The consequence of this alteration was not confusion in the moment, but fragmentation over time. Each office retained a piece of the record. The county clerk held the re-recorded instrument. The surrogate's court retained references to exhibits now sealed. The trust company maintained internal correspondence that was never filed at all. No single location preserved the complete picture. Without the internal map, the minutes, the letters, the cross-indexes, the case ceased to be navigable. This mattered because future access depended on continuity. An heir seeking information would encounter a record that acknowledged the trust's existence while withholding the logic that governed it. The law would recognize the instrument. The institution would enforce its terms. But the path from one to the other would be invisible. The alteration also changed how time functioned within the trust. Under the original indenture, time moved toward resolution. Under the codicil, time became a neutral factor. Compliance had to be sustained, not achieved. Review could be reopened at any point. Delays no longer implied failure. They became part of administration. The trust could persist without violating its own language. Importantly, nothing in the alteration required disclosure to beneficiaries. The codicil did not need to be served. its authority derived from recordation and fiduciary acceptance. Once the trust company adopted the revised posture, the change was effectively complete. The estate's outward form remained intact. Its internal mechanics shifted. The ethical tension embedded in this move is not explicit in the record, but it is legible in its structure. When a document is rewritten to neutralize the effect of another, intention migrates from family preference to institutional process. What begins as protection becomes policy. What appears as stewardship becomes permanence. By the end of 1897, the trust had been transformed without being publicly altered. The inheritance still existed. The file still bore the same name. The index still pointed to the same estate, yet the space between recognition and access had widened into a corridor only administrators could traverse. The alteration did not remove anything, it repositioned everything. And as the amended pages were filed, nearly identical in appearance, subtly divergent in language, the record settled into its new shape. Two versions, bound in the same archive, one quietly overriding the other, waiting for someone to notice that the door had not been closed, but moved just out of reach. By 1898, the effects of the 1897 codicil had begun to surface in ways that were administrative rather than textual. The trust itself no longer changed, but the way it was handled did. In the New York County Clerk's office, marginal notes appeared in the internal ledgers used by staff, not in the public-facing index. These notes did not explain substance, they redirected procedure. A clerk encountering the trust's file was instructed to verify with trustee correspondence before producing anything beyond the face instrument. The action was subtle and concrete. Access was rerouted. This mattered because 19th century record-keeping relied on continuity of handling as much as continuity of text. Clerks rotated, files moved, requests were processed by habit. When a case required deviation, it was flagged quietly so the deviation could be repeated without explanation. Over time, this became the only way the trust was known. Inside the office, new staff learned not the reason, but the rule. The consequence was institutional memory without narrative, knowledge that something was different without a record of why. In 1899, certification practices reinforced this shift. When copies of the trust instrument were requested, the certified extracts reproduced only the re-recorded language. Attachments referenced in the text were acknowledged but not included, cited as on file without direction. This was not omission by error. It followed the restricted handling designation. The act of certification itself became a filter, producing documents that were technically complete, yet practically incomplete. The trust company's internal processes mirrored this fragmentation. Annual statements continued to be generated, but they referenced internal file numbers rather than docket citations. These numbers had meaning only within the company's own archives. To an outsider, the statements confirmed activity without clarifying structure. The consequence was a growing divergence between what the public record affirmed and what only administrators could interpret. Indexing practices compounded the effect. The trust remained indexed under its original family designation, but cross-references that would normally link amendments to prior filings were not expanded. The file did not branch, it folded inward. Researchers relying on standard chain-of-document logic would see continuity where there was, in fact, substitution. The alteration became legible only to those comparing physical pages, not to those tracing citations. By the early 1900s, this approach produced a predictable outcome. Heirs or representatives seeking clarity encountered consistency without transparency. Every document pointed to legitimacy. Every inquiry confirmed existence, yet no path led forward. The system responded correctly at each step, while denying the possibility of resolution. The trust did not resist inquiry. It absorbed it. The institutional consequence was durability. Because nothing appeared broken, nothing required repair. Courts had no cause to intervene. Clerks followed protocol. Trustees exercised discretion. The estate continued to exist in a state of managed suspension, neither distributed nor contested. Its alteration had succeeded not by force, but by alignment with routine. What survived from this period are traces rather than explanations. A certification stamp dated 1902 that omits attachments, a ledger notation that redirects a request, a reference number that resolves nowhere outside an internal file. Each is ordinary in isolation. Together, they form a pattern of controlled incompleteness. The alteration, then, did not end in 1897. It propagated. It trained institutions to behave as if the trust were whole, while ensuring that no single institution could reconstruct it alone. The inheritance was no longer hidden. It was dispersed across procedures. By the time the file was boxed and shelved for long-term storage, its transformation was complete. The paper remained, the language held. But the connective tissue had been thinned to the point of invisibility. And as later decades inherited this handling without its origin, the trust settled into a new state, stable, authoritative, and quietly unclaimable, poised for the next question the record itself would raise: who exactly benefited from this permanence? By 1901, the trust had settled into a phase that no longer required revision or defense. It required only administration. The annual statements from that year, preserved in fragments across institutional archives, show a structure operating exactly as redesigned. The principle remained intact, distributions were deferred, and fees were assessed with regularity. The beneficiary line was unchanged. The administrator line was not. The entity now exercising practical authority over the estate was the U.S. Trust Company of New York, acting through its internal trust committee. On paper, this role was neutral. The company did not own the assets, it managed them. In practice, however, management without termination produced a steady, compounding advantage. Each year, the trust remained undistributed, the administrator's position strengthened. The concrete action was routine and unremarkable. The principal was kept invested in conservative instruments. Income was allocated to maintenance accounts. Trustee fees were calculated as a percentage of assets under management and deducted before any consideration of distribution. None of this violated fiduciary standards. All of it complied with the revised posture adopted after 1897. The consequence was structural. Time itself became profitable. What made this arrangement effective was that it required no new justification. Once the trust had been reclassified as restricted and subject to trustee discretion, continued administration was framed as obligation rather than choice. Each year of management reinforced the previous one. Fees collected in 1901 were justified by activity in 1900. Activity in 1900 was justified by unresolved conditions from 1899. The chain extended backward without ever reaching a point that demanded closure. The beneficiaries, by contrast, remained theoretical. Their eligibility depended on conditions that were perpetually under review. Requests for clarification did not trigger denial. They triggered process. The trust committee evaluated, deferred, and documented. The absence of distribution was not recorded as refusal, but as pending determination. Legally, nothing was withheld. Institutionally, nothing was released. This distinction mattered because it insulated the administrator from scrutiny. A trustee who denies a qualified beneficiary invites challenge. A trustee who continues to evaluate compliance invites patience. The latter posture aligned perfectly with fiduciary language and judicial deference of the era. Courts were reluctant to second-guess trustees acting within discretion, especially when no obvious harm could be demonstrated. An heir without access could claim frustration. An administrator with documentation could claim diligence. Financially, the benefits accumulated quietly. Trustee fees, though modest by percentage, compounded over years of management. Custodial control of securities allowed the trust company to participate indirectly in voting and corporate governance tied to the assets. Real property associated with the estate required maintenance, staff oversight and tax payments, all routed through accounts managed by the trustee. Each function reinforced the administrator's centrality. The arrangement also conferred institutional leverage. A trust that endured without dispute enhanced the company's reputation for stability. It demonstrated the ability to manage complex estates across generations, a selling point in an era when families feared dissipation more than stagnation. The trust became a case study in control, cited implicitly rather than publicly. Its success was measured not by distribution, but by endurance. The silence surrounding the beneficiaries was not incidental. It was advantageous. Without a named recipient pressing a claim, there was no focal point for conflict. The trust existed as an entity rather than a promise. Its obligations were abstract. Its authority was concrete. The administrator occupied the only position that translated into action. By the early 20th century, this model was not unique, but it was refined. Trust companies had learned that indefinite administration reduced risk. It minimized litigation, stabilized revenue, and aligned institutional incentives with inertia. The longer a trust remained unresolved, the less likely it was to be resolved at all. Each passing year normalized the absence of an heir. The consequence extended beyond accounting. Control over assets without obligation to deliver them altered the balance of power embedded in the estate. Decisions about investment, maintenance, and even documentation flowed through the trustee. The family name persisted in indexes and references, but operational authority had shifted. What began as a mechanism to protect reputation had become a durable arrangement that favored the administrator's permanence over the heir's access. Importantly, this did not require malice. No evidence suggests overt exploitation or fraud. The system rewarded compliance with its own logic. Trustees acted within the scope granted to them. Fees were disclosed, statements were prepared, the trust functioned as designed. The beneficiary, by contrast, existed only as a condition not yet satisfied. By 1905, the pattern was established. Annual reviews repeated familiar language. Distributions remained deferred. The trust company's role was unchallenged. The estate generated stability rather than transfer. The silence that surrounded the trust was not protective of the heir. It was protective of the arrangement. What this reveals is not a villain, but an alignment. The interests of the trustee, the court, and the broader institutional environment converged on a single outcome: continued administration. The trust no longer needed to be defended against claim. It needed only to be maintained. As the files from this period show, maintenance leaves traces, fee schedules, investment summaries, internal references. What they do not show is movement toward resolution. The inheritance remained illegally present and practically inaccessible. The beneficiary remained acknowledged and unrealized. The administrator remained indispensable. And so, by the time the trust entered its second decade, the question of who benefited had an answer that did not appear in any family tree. It appeared in balance sheets, committee minutes, and routine certifications. The silence was productive. The system was self-sustaining. The block closes not on a name, but on a line item. A trustee fee deducted. Recorded and carried forward. Ink on a ledger that confirms control without transfer, setting the stage for the next change when something else would begin to vanish from the record altogether. In 1903, the trust's endurance stopped looking like a matter of paperwork and began to show up in the physical world, where wealth is easiest to trace, not in a courtroom, not in a newspaper, in a property index. The address itself had been stable for years. A townhouse in Manhattan, the kind of residence that anchored a family's public identity, recorded through ordinary channels that anyone with patience could consult. Deeds, conveyances, mortgages, releases. The chain of title was, at first, conventional. A recognizable surname appeared in the grantor and grantee lines. Clerks indexed it under the family name, and the record behaved as property records are meant to behave. It pointed outward, letting the public locate ownership without knowing anything else. Then, in 1903, the surname stopped appearing. The change did not occur as an abrupt removal. It occurred as a re-indexing event tied to custodial language. A deed entry that should have carried the family's name was indexed instead under a generic institutional form, something like Trust Co., Trustee, a designation common enough to avoid attention but precise enough to function as a barrier. The property did not disappear, the owner did. The concrete action behind this was clerical and deliberate. The entry was recorded in the appropriate ledger, and the index card that would normally connect the property to the family name was revised. Whether the underlying deed described the trust explicitly or simply referenced a trustee entity, the effect in the public index was the same. The property became searchable through institutional custody rather than personal identity. This mattered because public search behavior relied on names, a curious reporter, a distant relative, a creditor, even a marriage. Negotiator looking for assurances did not begin with parcel numbers. They began with surnames. They checked indexes. They followed reputational trails. When the name vanished from the index, the trail broke. The press could no longer confirm ownership through standard inquiry. Potential challengers could not easily locate assets to attach. Heirs could not reconstruct the estate by searching what should have been the simplest component, real property. The institution involved was not abstract. In this case, the administrative imprint points back to the same ecosystem that governed the trust, a trustee entity acting in concert with a trust company, operating under the logic of restricted handling that had already reshaped the estate file. The property record did not need to explain the trust's conditions or its internal disputes. It needed only to reflect custodianship in a form that reduced vulnerability. The consequence was immediate in practical terms. If an heir sought proof that the family still controlled the residence, the public record offered no direct confirmation. If a banker sought collateral certainty, the name-based linkage was gone, replaced by institutional custody that required deeper inquiry and often cooperation from the trustee. If a journalist sought a narrative of inheritance and decline, the visible evidence had been turned into a dead end. There is a common assumption that property records are immune to narrative management because they are technical. In reality, they are administrative systems that reflect how entities choose to present ownership. In 1903, the presentation shifted. The townhouse did not change location, and it did not necessarily change use. But its identity as a family-held asset was muted. The building became an administered object rather than a named inheritance. The chain of title still existed, but it became harder to traverse without specialized knowledge. index entries referenced legal descriptions rather than social identity. Filings relied on trustee designations that made sense only if one already knew the trust existed. To anyone outside that circle, the record appeared ordinary, just another property held by a trustee entity. It did not read as concealment, it read as administration. That is what made it effective. A disappearance that looks like routine does not invite investigation. A missing name does not trigger a legal event. It triggers confusion, and confusion discourages pursuit. The C record remains intact, but the human pathway through it is disrupted. The deeper consequence was strategic. Once a key property could be held under an institutional label, the estate could be defended without litigation. Ownership could be maintained while visibility declined. The trustees could preserve control and reduce the number of people capable of proving that control existed. It was a form of soft security, achieved not by hiding assets, but by changing how they could be found. This also altered social dynamics. In the Gilded Age, a townhouse was not merely shelter, it was signal. Its ownership anchored invitations, alliances, and assumptions about permanence. When the family name stopped appearing in the property index, the townhouse became less useful as public proof of standing. Yet the trust's logic suggested that public proof was no longer the priority. Control was. The disappearance, then, was not only documentary, it was reputational management through administrative design. By shifting the record from surname to trustee entity, the estate insulated itself from casual scrutiny while preserving the legal foundation required to keep operating. What survives from 1903 is the evidence of a break in continuity. A search that once yielded results no longer does. An index that once spoke a name now speaks a function. The property remains, but the identity attached to it has been thinned to institutional language. And the block ends with a concrete artifact that captures the change without commentary. A single line in a deed index, dated 1903, where the familiar surname is absent, replaced by a trustee designation. An entry that doesn't explain what happened, only confirms that something, somewhere, was intentionally made harder to find. In 1912, the case stops being defined by what is missing and begins to be defined by what refuses to match. The disappearance of a surname from a property index in 1903 can be explained away as a technical shift in custody. A restricted file can be defended as prudence, but when independent records that should align begin to diverge, when the court's numbers and the trustees' numbers describe two different estates, the issue is no longer visibility. It is internal coherence. The inconsistency appears only through comparison because neither record announces it. In the Surrogates Court of New York County, the docket book preserves the estate inventory as it was presented in probate. A formal valuation, recorded with clerical certainty, tied to a specific filing sequence that reflects the court's understanding of what the estate contained at the time. Separately, the trustee ledger maintained by U.S. Trust Company of New York reflects what was actually being administered years later: principal balances, income allocations, maintenance accounts, and fee deductions, documented through annual handling. The action that exposes the gap is simple and concrete. The inventory figure recorded in the probate materials is set against the principal shown in the trustee accounting for the same estate. In 1912, they do not match. The discrepancy is not marginal, it is structural. There are only a few benign explanations for such a divergence. Assets can appreciate, securities can be replaced, property can be sold, but those changes leave traces. They appear as transactions, schedules, or court-approved accountings. Here, The divergence appears without the connective tissue that should exist. Between the court's baseline and the trustee's continuing reality, the numbers do not tell a story of ordinary management. They suggest an event that has been filed in a place that does not connect cleanly to either record. The docket book provides one anchor, a dated entry that indicates the estate's accepted valuation and the court's closing posture. It implies completion. The trustee ledger provides another, continuing administration with a principle that implies either additional assets were absorbed into the trust after probate, or that the probate inventory did not reflect the full scope of what would later be administered. Both scenarios are consequential because both involve a change in legal posture that should have required documentation. The inconsistency is not confined to valuation. It appears in signatures and sequencing. In the surrogate's court packet, the signature placement on a later page certification does not follow the usual order. The clerk's attestation appears on a page that by its numbering should precede it. The date stamp on one document is offset by days in a way that breaks the expected chronology of filing and certification. These are small details, but in court records, sequencing is itself a form of meaning. A date out of position is not merely a typo. It can indicate that an item was inserted later after the packet had been prepared. In the trustee ledger, a parallel irregularity appears. A line item referencing an internal file number is associated with a date that does not correspond to any publicly accessible docket event. It reads as if a directive was issued, an instruction that reshaped handling without appearing as a court order, a public amendment, or a recorded deed event. The ledger reflects the instruction's effects, not its existence. This is where the possibility of an intermediate document becomes more than speculation. When institutions behave as if they have received an instruction, and yet the instruction does not appear in the usual channels, it typically exists in a category designed to avoid ordinary visibility. In the late 19th and early 20th centuries, that category often took the form of letters of instruction, sealed exhibits, supplemental memoranda, or committee directives that were never filed with the court as standalone instruments. They were treated as administrative inputs rather than legal events, even when their practical impact was decisive. The consequences of such a document are measurable. It would explain how a trust could administer a principle that exceeds the probate inventory without an obvious public transaction trail. It would explain why certain exhibits were sealed and why later certified extracts omit attachments while still referencing them. It would explain why a property record could be indexed under trustee custody without the family name appearing, while still preserving legal continuity in internal systems. The fact that this inconsistency surfaces in 1912 is also significant historically. This is not a quiet period in American institutional life. Financial standards are tightening. The progressive era is pushing for greater accountability in corporate governance and public administration. Trust companies are becoming more central, but also more scrutinized. A discrepancy in estate handling at this moment is not merely a clerical inconvenience, it is a vulnerability. If an heir or a creditor were to notice that the court's declared inventory does not align with the trustee's administered principle, questions would follow that neither institution would want to answer. Was the inventory incomplete by design? Were assets moved post-probate under a discretionary authority that was never tested in court? Were maintenance accounts being used to absorb property or securities without clear public linkage? Each question has legal implications. Each question risks turning an administrative arrangement into a contested one. And yet, the record does not show a contest. It shows adjustment without confrontation. That is why the inconsistency matters. It suggests that whatever corrected the divergence did so quietly, through channels built for preservation rather than disclosure. There is also a social consequence that is easy to overlook. Inheritance is not only about money, it is about proof. A probate inventory is a public declaration of what existed at death. A trustee ledger is a private account of what persists afterward. When those two accounts disagree, the very idea of what the family owned becomes unstable. That instability favors the institution that controls the private record, not the heir who relies on the public one. The tension in 1912 is therefore not merely numerical, it is evidentiary. Two authoritative systems describe the same estate differently, and the difference cannot be reconciled with the documents that remain accessible. The missing link is not only a document, it is the bridge between public closure and private continuation. This block ends where such investigations typically pause, at the point where the evidence indicates a directive exists but does not reveal its form. The last thing the surviving paper gives us is a contrast. An inventory figure in a court docket and a larger principal figure in a trustee ledger, two numbers that should converge, recorded in different hands, separated by years, and held together only by the trust's name. By 1913, the discrepancy no longer lived only in parallel ledgers. It began to surface in the margins, where institutions try, quietly, to reconcile what should already agree. A set of review notations appears in a supplementary accounting prepared for the U.S. Trust Company of New York, indicating that figures were restated for continuity. The action is procedural and specific. Values are recalculated without altering the underlying assets, and the prior year's balance is carried forward as if it had always been the baseline. The consequence is subtle but decisive. The mismatch is normalized on paper without being explained. What makes this moment distinct is that reconciliation occurs without disclosure. There is no amended probate inventory in the surrogate's court file. No supplemental schedule is entered to bridge the gap between what the court accepted and what the trustee administered. Instead, the trustee's accounting absorbs the difference by adjusting its own internal references. The estate does not change, the numbers do. The public record remains frozen, the private record adapts. A further irregularity appears in the method of valuation. Earlier probate materials reflect asset values consistent with conservative estimates used at the close of the 19th century. The trustees' restated figures, by contrast, align with later appraisal practices, incorporating appreciation and substitutions as if they were original conditions. The action is technical, valuation basis is shifted, but the consequence is legal ambiguity. An heir comparing records cannot tell whether assets were added, reclassified, or simply remeasured. Each explanation carries different rights. None is documented. The paper trail shows signs of friction. In a correspondence index maintained by the trust company, an entry from 1913 references a clarification requested from counsel, followed by a note indicating no further action required. The document itself does not survive in the accessible file. What survives is the decision not to pursue formal correction. The inconsistency is acknowledged internally and then set aside. This pattern repeats in how certifications are issued. Certified copies prepared after 1913 rely exclusively on the trustee's adjusted figures when summarizing the estate's status, while still citing the original probate docket number. The action is to merge incompatible sources into a single output. The consequence is that later readers encounter a hybrid record, one that looks consistent only because its seams have been concealed. The institutional logic behind this is clear even without explicit explanation. Correcting the probate inventory would reopen a closed proceeding. It would invite questions about omissions, authority, and timing. Leaving the discrepancy unresolved in public but resolved in practice avoids that risk. The system chooses continuity over coherence. There is also a timing element that deepens the inconsistency. A date associated with one restated figure precedes the internal memo authorizing its use. The sequence is reversed. In strict terms, the accounting reflects a result before the instruction that permitted it. The action here is backdating through presentation, not alteration of the past, but alignment of it. The consequence is a record that appears orderly while defying chronology. By 1914, the effect is cumulative. Anyone attempting to reconstruct the estate encounters a closed court file that implies completion, alongside an active trust account that implies expansion. The two do not converge. The missing link is not simply a document, but a moment, a point at which authority shifted without leaving a public trace. The social cost of this inconsistency is borne by those without institutional access. Heirs can demonstrate lineage, but not entitlement. Creditors can identify assets, but not ownership. Journalists can confirm administration, but not origin. Each inquiry stops at a boundary defined by procedure, rather than law. This extension of the inconsistency matters because it shows intention without confession. The institutions involved behave as if the discrepancy is known, managed, and contained. They do not behave as if it is an error requiring correction. The difference between those two postures is the difference between mistake and method. The record ends this phase with a quiet alignment. The trustees' figures prevail in practice, the court's figures persist in form, and no document bridges them. The last artifact from this period is a restated balance sheet initialed in 1914, consistent within itself and incompatible with the probate inventory it still references. An image of order built on unresolved difference, setting the stage for the next question the estate could not afford to answer publicly. What would happen if someone forced these numbers into the same room? By 1916, silence stopped being neutral. What had once been an advantage became a liability, not because the trust had changed, but because the environment around it had. The same opacity that protected the estate through the turn of the century now intersected with a legal and fiscal landscape that no longer tolerated ambiguity without consequence. That year marked a structural shift in how wealth was scrutinized in the United States. New federal approaches to taxation and reporting began to treat estates not merely as private arrangements, but as units of public interest. The Bureau of Internal Revenue, precursor to the modern IRS, expanded its reach over inherited wealth, especially where trusts were involved. What had once been a matter of private administration was now subject to classification, valuation, and explanation. For a trust that appeared perpetual, restricted, and internally inconsistent, this scrutiny posed a specific risk. If the estate's handling were reviewed, the mismatch between probate inventory and administered principal could not be explained as appreciation alone. Questions would arise about whether assets had been withheld, reclassified, or deliberately insulated from distribution. The issue would not be framed as moral failure, but as compliance failure. The legal exposure extended beyond taxation. Under New York law, fiduciary duty had become a sharper instrument. Trustees were increasingly expected to demonstrate not only diligence, but good faith in facilitating eventual distribution where appropriate. A beneficiary who could show that access was indefinitely blocked by discretionary interpretation rather than objective failure, could petition the New York Supreme Court for review. Such a petition would force the trust's internal logic into public view. The action taken in response to this threat was preemptive. Legal counsel prepared a defensive strategy designed not to resolve the trust, but to insulate it from reclassification. This included tightening the language used in external communications, avoiding any acknowledgement that conditions were impossible, and framing all delays as ongoing evaluation. Internal memoranda emphasized consistency over clarity. The goal was not to explain the trust, but to make it procedurally unassailable. This strategy had a clear consequence. It raised the cost of exposure. Any challenge would require a claimant to assemble fragments from multiple institutions, court dockets, trustee ledgers, property records, none of which, on their own, demonstrated wrongdoing. The burden of proof shifted. Outward, silence, once passive, became an active shield. The press represented a parallel risk. By 1916, newspapers were more willing to examine the mechanics of elite wealth, especially in the context of wartime finance and public sacrifice. A story about an inheritance that existed in law but not in practice would resonate not as gossip but as structural inequity. It would invite questions about fairness, privilege, and the manipulation of legal forms. For families whose influence depended on discretion, such attention was destabilizing. Social consequences followed naturally. Elite alliances were built on assumptions of transparency within closed circles. If a trust were exposed as a mechanism to deny heirs while enriching administrators, it could disrupt marriage negotiations, philanthropic commitments, and positions on institutional boards. The damage would not be confined to the estate. It would ripple through networks that depended on perceived integrity. Financial markets amplified this risk. Banks extending credit to families tied to the trust relied on stable representations of asset control. If a court or tax authority questioned the trust's structure, collateral assumptions could be revisited. Loans could be restructured, guarantees could be withdrawn, the estate's quiet stability would be replaced by transactional friction. What made 1916 particularly dangerous was timing. The trust was no longer young enough to be dismissed as unresolved, nor old enough to be forgotten. Its longevity invited scrutiny precisely because it suggested design. An arrangement that persisted through decades without distribution could no longer be framed as patience. It looked like intent. The institutions involved were aware of this. The absence of public filings from this period is itself telling. No clarifying amendments were recorded. No petitions for instruction were submitted to the court. Instead, the estate was held in its existing posture, as if motion itself would draw attention. The strategy was inertia. The consequence of failure, however, was severe. If a single proceeding forced disclosure of internal correspondence or committee directives, the trust could be recharacterized as obstructive. Trustees could face questions of fiduciary breach, past fee structures could be examined, property holdings could be re-evaluated. The silence that had once protected the arrangement would become evidence of concealment. This is why the risk of scandal in 1916 was not hypothetical, it was calculable. It sat at the intersection of law, tax, and press, each reinforcing the other. A tax inquiry could trigger legal review. Legal review could attract media attention. Media attention could destabilize social and financial relationships. The cascade required only one point of entry. The response was to make that entry as narrow as possible. Counsel advised restraint. Trustees documented process without explaining substance. Communications were standardized. References to ongoing review replaced any language of resolution. The trust remained active but static. This posture carried its own cost. It committed the estate to indefinite defense. Every year without distribution increased the potential damages of exposure. Every additional fee collected strengthened the appearance of self-interest. The system became dependent on its own opacity. The risk, then, was no longer about whether the trust could be challenged. It was about whether it could survive being understood. The block ends with a moment that captures this tension without dramatization. A legal memorandum dated 1916, prepared for internal circulation, outlining potential exposure under new tax scrutiny and recommending no change to existing practice. An object that does not accuse but anticipates, and in doing so reveals how close the arrangement had come to being forced into the open. By 1924, the trust no longer depended on secrecy in the dramatic sense. It depended on routine. What had once required careful legal posture and controlled paper trails now relied on something quieter and more durable. Standardized language that made absence feel procedural. The trust survived because it had learned how to sound ordinary. The administrative memoranda from this period do not read like a defense. They read like maintenance. The vocabulary is consistent across institutions that, on paper, have different roles. The trustees' internal committee, the trust companies, operations staff, and the clerical custodians at the New York County Clerk's Office. Each uses the same terms to describe the same restrictions, as if the restrictions were simply part of the file's nature rather than the product of decisions made decades earlier. This is how the silence becomes normalized. It is not enforced through explicit refusal. It is enforced through categorization. A file labeled restricted does not provoke debate. It triggers a workflow. It tells staff what not to do. It limits who can view exhibits, what can be copied, and what can be released without secondary review. The action in 1924 is concrete. The trust's case packet is formally classified as a restricted file, and access is limited to partial extracts, with attachments and supporting exhibits treated as controlled materials. Clerks handling requests are instructed to provide only the face instrument or certified summaries, and to refer inquiries about exhibits to the trustee's office. The language used to justify this is deliberately neutral. Conditions of the settler, protection of third parties, administrative preservation. These phrases do not accuse anyone of wrongdoing. They imply responsibility. They make restriction appear ethical. The consequence is institutional consent. Employees who never met the original trustees treat the restrictions as normal safeguards, not as evidence of a disputed or manipulated inheritance. The trust company's internal committee, often described in surviving indexes simply as a trust committee, adopts a parallel vocabulary. Instead of discussing beneficiaries in terms of rights, memoranda refer to eligibility review. Instead of acknowledging that exhibits have been withheld, documents refer to file completeness maintained under preservation protocol. Instead of describing payments as indefinite administration, statements refer to maintenance accounts, as though the trust's purpose has shifted from distribution to upkeep as a matter of course. In practice, this changes how questions are handled. When an inquiry arrives, it is not escalated as a threat. It is processed as a category. A beneficiary request becomes an eligibility file review. A genealogical question becomes a third-party inquiry. A court clerk's request for attachments becomes an exhibit access request, automatically limited by default. The system does not need to argue. The vocabulary does it. The county clerk functions as the bureaucratic guardian of this normalization. Once a file is marked restricted, the clerk's role is not to explain why, but to enforce the label. The label becomes the reason. Over time, the original basis for the restriction is no longer required for enforcement because enforcement is justified by precedent rather than principle. This is what makes 1924 different from earlier years. In 1897, restriction is an act. In 1916, it is a strategy. In 1924, it is a procedure. The real consequence is generational. New staff are trained on process, not history. They learn that this trust has controlled exhibits, controlled access, controlled handling. They do not learn that the controls were once contested internally, or that they emerge from fear of scandal and legal scrutiny. They inherit the routine without inheriting the reason. And that is precisely what makes the routine stable. Even the physical management of documents reflects this shift. Papers are referenced as objects to be preserved rather than read. Preservation of papers becomes the phrase that justifies the file's partial visibility. The goal is no longer to keep secrets from the public by force. The goal is to keep the record in a state where its most revealing components remain permanently categorized as material that should not circulate. The effect on the investigative trail is immediate. From this point forward, anyone attempting to reconstruct the trust encounters language that blocks narrative. Restricted. Maintenance. Preservation. Each term suggests that what is missing for a legitimate reason. None suggests that missing material might be essential to understanding how the inheritance became unreachable. This also changes how courts would perceive future disputes. If restriction has been normalized for decades, it appears as long-standing practice rather than reactive concealment. A trustee defending the trust in later years can point to procedural continuity. They can say the file has always been handled this way. In institutional terms, continuity becomes legitimacy. What is striking is how little is required to sustain this. No new codicils appear, no new court orders surface. The trust persists by repeating the same language in the same places year after year until the language itself becomes the structure. This is controlled truth not through lies, but through constrained vocabulary, words that acknowledge the existence of material while preventing it from functioning as evidence. The silence, by 1924, is no longer a gap in the record. It is part of the record's design. It is the mechanism that replaces explanation. It is how the trust continues to exist without being fully knowable. The block ends with a concrete image that captures the normalization. A file jacket in an archival box, stamped restricted, with a routing slip dated 1924 clipped inside. No explanation, no narrative, only procedure. An object that shows how a decision becomes routine once enough. Institutions agree to treat it as ordinary. After 1925, the normalization of silence advanced through accumulation rather than instruction. No single memo explains it, but the pattern becomes visible in the way routine actions are logged. Each year adds another layer of procedural certainty, reinforcing the idea that the trust's opacity is not an exception to be managed, but a condition to be maintained. Annual reviews now follow a template. The same phrases recur with minimal variation, not because they are legally required, but because they have proven sufficient. Language hardens into form. Where earlier records hinted at discretion, later ones assume it. The trust is described as under continuing administration, a phrase that does not imply resolution or failure. It implies stability. The action here is repetition, and its consequence is authority through familiarity. What changes most noticeably is how absence is handled. Missing exhibits are no longer flagged as withheld. They are referenced as retained. Questions about valuation are redirected to prior determinations. Inquiries that once might have triggered review now trigger citation. The record begins to answer itself, not with facts, but with precedent. Silence is no longer defended, it is cited. This procedural maturity alters how time is perceived within the file. Earlier decades treated delay as something to be justified. By the late 1920s, delay is treated as the default state. No one asks how long. Administration should last because duration has ceased to be a metric. The trust exists to be administered, not concluded. That premise, once implicit, is now assumed. The effect on oversight is significant. When an institution reviews a file that has behaved consistently for decades, deviation appears riskier than continuation. Staff learn that the safest course is to preserve the existing handling, even if its origins are unclear. The action taken, again, is minimal. Follow the file's established posture. The consequence is maximal. The trust structure becomes self-reinforcing. This also reshapes accountability. Responsibility is diffused across time. No individual clerk, trustee, or committee member is responsible for the original restriction, and none is responsible for lifting it. Each acts within inherited limits. When authority is distributed this way, challenge loses its target. There is no decision-maker to confront, only procedure to navigate. The normalization extends beyond documents into training and habit. New personnel are instructed in what the file allows, not why. They are taught which pages may be copied, which references may be acknowledged, which terms to use when responding to inquiries. The record becomes an object of compliance rather than inquiry. Knowledge is operational, not interpretive. By 1930, the trust's handling has achieved a form of institutional anonymity. It is no longer remarkable. It no longer attracts special attention. It exists as one more restricted case among many, even if its restrictions are unusually complete. This anonymity is protective. Files that do not stand out are less likely to be reopened. The normalization also affects external perception. Any party encountering the trust through official channels sees consistency rather than contradiction. The same responses are given to different questions. The same limitations are applied regardless of who asks. Uniformity replaces explanation. In institutional systems, uniformity is often mistaken for correctness. What is lost in this process is not a document, but a memory of contingency. The trust's current posture appears inevitable, as if it could never have been otherwise. The fact that it emerged from specific fears, calculations, and strategic choices recedes entirely. The silence no longer conceals those origins, it renders them irrelevant. The consequence for future inquiry is profound. To challenge the trust now would require not only evidence but disruption of routine. It would require someone to argue that what has been treated as normal for generations is, in fact, an anomaly. That is a heavier burden than proving a single act of concealment. It requires confronting the legitimacy of procedure itself. This extension of silence does not close the case, it stabilizes it. The trust persists, not because it is unresolved, but because it has been resolved into a process that has no endpoint. The record continues to exist. Accessible in form and inaccessible in substance, carrying forward a controlled version of truth that no longer needs defense. The block concludes with an image that captures this stage of normalization. A response letter prepared in the early 1930s, typed on institutional letterhead, granting a request to the extent permitted under established handling, signed without commentary, filed without reaction, an object that shows how silence, once deliberate, becomes simply how things are done. In 2026, the trust does not return because someone confesses or because a sealed box is opened by accident. It returns because the century that protected it was analog and the century that follows it is indexed. The modern trigger is mundane. The Surrogates Court of New York County expands digitized finding aids, scanned docket references, searchable name indexes, and metadata that makes old entries discoverable by people who never would have walked into a records room. At the same time, genealogical research has become procedural. Descendants build lineage through public methods, connecting censuses, birth records, death certificates, and newspaper notices into a chain that can be printed, notarized, and submitted as evidence of relationship. Platforms like Family Search matter here not as proof in themselves, but as a model for how modern researchers work. They assemble, cross-check, cite, and document. That combination, searchable indexes plus disciplined genealogy, reopens a file that the 20th century trained institutions to treat as routine silence. A descendant begins with a name, then discovers the problem the record has been designed to create. The name stops appearing where property and wealth should be easiest to track. So the search shifts to institutional language: trust, trustee, committee, restricted. In the digitized index, those words become navigable, and that is how the trust appears again, not as a story, but as an entry that refuses to behave like a closed estate. The concrete action in 2026 is procedural. A formal request is filed for the trust packet referenced under the court's index entry, an administrative slip, a case reference number, a request for the register card, and any associated exhibits. The records desk responds with what it can release. Not everything, not the sealed attachments, not the internal correspondence, but enough to confirm something that should not be true if the family's own narrative were accurate. The trust is still treated as active in the court's institutional memory, even if no beneficiary has ever been recorded as having received it. The pages that come back are not dramatic. They are dry. They carry stamps and clerk notes, not explanations, but they also carry the modern signature of controlled access, redactions. In the released packet, certain names are blacked out. Certain cross-references are present as numbers without destinations. Exhibits are listed but not included. A page will refer to an Exhibit C without attaching it. Another will cite an instruction letter without revealing its content. A third will preserve a trustee determination clause but remove the portion that would identify who made the determination. The trust is visible as structure and invisible as mechanism. That is the practical meaning of restricted in the present. It is not a wall. It is a filter that lets the architecture be seen while withholding the map. The consequence is immediate for the descendant. Modern eligibility is not tested by intuition, it is tested by documentation. The trust's conditions, as preserved in the instrument, demand proof that is not realistic across generations. Continuous residency requirements, approval of marriage by trustees who no longer exist as individuals, standing attested by third parties whose identities are not recorded in the accessible file. Even when the descendant can prove lineage, the trust is not a simple inheritance. It is an administrative obstacle course designed for a world in which the administrators controlled the definition of success. The first barrier is procedural standing. To seek more than partial release, the descendant must demonstrate a legally recognized interest in the file. But the file's structure makes that circular. You need the exhibits to prove eligibility, and you need eligibility to access the exhibits. The institution does not present this as denial. It presents it as policy. Additional materials require proof of interest. The language is calm. The effect is total. The second barrier is institutional continuity. The court record points outward, toward a trustee structure that is still referenced by name, but no longer explained by context. The packet contains references to a trust committee and administrative determinations made in prior decades, but it does not contain the determinations themselves. It suggests that an institution holds the authoritative narrative and the court holds the shell. The descendant can see that decisions were made. They cannot see the basis on which the decisions were made. The third barrier is evidentiary fragmentation, now made visible by digitization. The researcher learns quickly that no single archive contains the whole story. The New York County Clerk's Office may hold recordations and re-recordings of the instrument. The surrogate's court holds docket references and the public face of probate. A trust company's successor archive may hold internal accounting. Property records sit elsewhere, indexed under trustee language that breaks the name-based trail. Digitization makes the fragments easier to find, but it does not reunite them. It reveals with clarity how well the system was designed to distribute knowledge across institutions that do not share their internal maps. In practical terms, the trust remains intact because it still has institutional life. It is referenced, it is handled, it is preserved under categories that trigger modern workflows. The descendant's claim, however, lacks institutional life. It exists as a request without an accepted path. The trust is treated as a living administrative object. The heir is treated as an external inquiry. The most revealing feature of the 2026 response is what it does with time. Nothing in the release suggests urgency. There is no acknowledgement that the trust has outlived its social rationale. There is no suggestion that conditions designed in the 1890s might be unreasonable now. The file is handled as if its age is irrelevant. The system treats time as neutral because its procedures were built to outlast the people they govern. A century passes, and the trust's posture remains the same. Restricted, maintained, preserved. This is not presented as cruelty. It is presented as continuity. That is what makes it so hard to challenge. In the descendant's packet, one modern clerk note captures the case's present tension more honestly than any historical phrase. It sits in the margin of an index printout, typed in neutral language. File contains restricted exhibits. Release limited to permitted materials. Refer additional requests to trustee counsel if applicable. The phrase, "if applicable," matters. It implies that the trustee may no longer be easily identifiable to the public. It implies that the living point of contact may be gone or may exist only behind legal counsel. The trust persists. The door remains, but the handle has been relocated. The consequence is also reputational even now. If the descendant pushes for litigation, the case becomes public in the very way the system was built to avoid. A petition in open court would require naming institutions, describing restrictions, and arguing that the structure itself functions as a barrier rather than a safeguard. That introduces risk to everyone involved, to administrators who have inherited the file, to institutions whose names appear in old references, and to any modern entity that stands in the trustee's place. The trust's greatest defense is that forcing coherence would cost more than most claimants can afford, financially, legally, and psychologically. And yet, digitization has shifted the balance in one critical way. The trust can no longer rely on obscurity. It can rely only on procedure. That is what makes 2026 feel different. The record is no longer lost. It is found, and still incomplete. The mystery is no longer whether the trust exists. It is why a structure designed for private control remains so effective under modern transparency tools. The old mechanisms did not need to be rebuilt. They only needed to be preserved. The present-day story does not end with a revelation. It ends with a document that confirms the paradox, a scanned PDF page from the surrogate's court packet, dated as a modern release in 2026, showing a century-old reference line and several black redaction bars across the names that would connect it to living people, an image of access granted and meaning withheld, closing the present on a single unresolved pressure point that leads directly into the final question. When an institution can preserve a trust indefinitely, who decides what counts as proof? And who decides when a legacy is allowed to end? On October 14, 2026, the search moves out of narrative and into logistics, the place where old structures survive best. After the surrogate's court release, the descendant's next step is not another theory, but a certified record request at the New York County Clerk's office for every re-recording and cross-reference tied to the trust's instrument number, including any schedules on file that the court packet only alluded to. The action is formal and concrete, a paid written application for certified copies and a complete index trace submitted with the case citation and the trustee-style grantee language that replaced the family name in earlier decades. What comes back is not a refusal, but something more institutional, a partial fulfillment notice and a set of documents that are cleanly stamped, properly dated, and still incomplete. The county clerk's certification confirms the existence of the re-recording chain, and it confirms that at least one schedule or attachment is referenced in the docketing notes, but the schedule itself is missing from what can be produced through ordinary retrieval. The explanation is administrative, not argumentative. The attachment is described as not imaged and held off-site, subject to special handling. In practice, the request is reclassified internally as restricted access retrieval, which changes the workflow without changing the answer. The descendant is told that the face instrument can be certified, but exhibits and schedules, where the trust's real-world assets would be enumerated, require either trustee authorization or a court directive. The consequence is immediate and practical. The descendant can prove the trust exists and can prove it was re-recorded, but cannot prove what it holds, which means they cannot connect the trust to the physical property and securities that would make the claim more than symbolic. This is where digitization shows both its power and its limit. Modern index search makes it possible to locate references that were once effectively buried, but digitization also creates a sharp boundary between what has been converted into accessible metadata and what remains trapped in analog. E-custody. The descendant can see the entry that points to the missing schedule. They can see the institutional language that implies there is more. They cannot obtain the more without stepping into the narrow procedural lane the 20th century built for exactly this purpose. The record itself now begins to behave like a controlled system. Every retrieval produces a correct document that points to a withheld document. Every cross-reference exists as a destination that cannot be reached. Without additional authority, the file does not hide, it redirects. This changes the nature of proof. In older disputes, you proved entitlement by showing lineage and compliance. Here, you must prove entitlement by producing the schedule that would show what you're entitled to claim. Yet the schedule is what you cannot reach. The structure turns evidence into a gate. A second, quieter barrier emerges from modern institutional turnover. The trust references entities whose names are historically legible but operationally unstable. The trust company named in older papers may have evolved, merged, or been absorbed, leaving the descendant with a present-day problem that is neither legal nor emotional, locating the current custodian of an old fiduciary role. A phone call leads to another department. A department refers to archival services. Archival services refer back to legal counsel. The action is procedural again. The descendant submits an affidavit of identity and a documented line of dissent, expecting that modern compliance culture will reward completeness. The response is not hostile, it is conditional. We can review, the communication implies, once you demonstrate a legally recognized interest. The consequence is a loop. Recognition requires the missing schedules, and the missing schedules require recognition. In this phase, even the redactions begin to function differently. They are no longer merely about privacy. They are about continuity of control. Names are removed not only to protect individuals, but to prevent the descendant from mapping responsibility forward into the present. A trustee's signature from a century ago is inert. A modern contact point is actionable. The record releases what cannot be used and withholds what can. By late 2026, the descendant has assembled something that looks, to a layperson, like a complete case. A court index entry, a re-recorded instrument, certified extracts, genealogical proof, and a trail of administrative responses confirming restricted handling. Yet the legal reality is that the essential linking document, the schedule that would connect the trust to its assets, remains outside ordinary reach. That gap has a real consequence beyond frustration. Counsel cannot draft a clean petition without risking immediate dismissal for lack of specificity, because courts do not compel broad fishing expeditions when the claimant cannot identify what is being withheld. The system has matured into a posture that defeats claims not by denying them, but by requiring a level of precision that the claimant cannot achieve without the very materials being controlled. The trust, meanwhile, continues to exist as an administrative object with uninterrupted institutional treatment. It generates correspondence, it triggers handling rules, it produces certified pages, and it persists without a recorded termination. In practice, it behaves like a living file with a dead public story. That is the present-day paradox. Transparency tools revive the outline, but procedure preserves the interior. The extension closes on a modern artifact that carries the old logic forward without acknowledging it. An email from the County Clerk's Records Unit dated October 28, 2026, attaching the certified re-recording and stating that the reference schedule cannot be produced under standard request, with a single line beneath it that reads like routine. Further release requires authorization. And behind that line, the same. Unresolved tension the file has carried for more than a century. Proof exists, access does not. By 2026, the case does not end in revelation. It ends in procedure. A digitized index revives a line that should have gone dormant long ago, and the surrogate's court can still produce pages that carry the weight of an old decision. Stamps, references, cross-citations, and the clean geometry of redaction where names and mechanisms should be. What returns to the surface is not a fortune in the hand, but a fortune in the record, alive enough to be handled, intact enough to be administered, and still arranged so that belonging remains conditional. Seen in sequence, the chain is almost too orderly to be accidental. In 1894, the indenture is placed on file with the New York County Clerk, giving the trust its public spine. In 1897, a codicil stiffens the instrument and shifts distribution from event to discretion, turning inheritance into a system that can delay without ever denying. By 1912, the numbers refuse to align, inventory against principle, public closure against private continuation, hinting at an intermediate instruction that can reorganize reality without leaving a visible hinge. In 1924, the vocabulary of restraint becomes routine, restricted, maintenance, preservation, words that sound like care while quietly limiting what can circulate. And in 2026, a descendant stands before the archive and receives what the 20th century perfected: confirmation without completeness, access without the map. The mechanism has never required a villain. It required only a design that survives its designers. Conditions that are technically achievable, yet practically unreachable. Trustee power that can be exercised as review. And bureaucratic language that turns absence into compliance. Once those parts are in place, control does not need to be renewed. It needs only to be maintained. The trust becomes less a promise than an apparatus. It does not have to break. The law to defeat the social meaning of inheritance. It has to outlast the people who might insist on it. This is the institutional moral hidden in plain sight. An inheritance can exist without ever belonging. It can persist as an administered asset, rotating through committees and custodians, paying fees, generating filings, and sustaining a kind of legal life that is separate from human possession. In the gilded world that built these structures, protection and containment were often the same. Viewed from different doors. The language of safeguarding could also be the language of exclusion. And the line between the two was not drawn by sentiment. It was drawn by what could be proved, by whom, and under what terms. In the quiet corridors of record-keeping, truth is not always erased. More often it is managed. It is placed behind categories that sound neutral. It is divided across offices that do not share their keys. It is preserved in fragments that confirm a shape, while withholding the joints. The trust at the center of this story did not need to vanish. It needed only to become difficult to verify in full, difficult enough that time would do the rest. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. And consider what lies beyond this single case. How many legacies remain true only because they were carefully administered so they could never be wholly tested in daylight. Subscribe so that you're here when the next sealed door finally opens. And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive not because they are powerful, but because the people who feared them built systems that could endure without witnesses.